Good morning and welcome to Training Thursday's December webinar. My name is Hermie Abraham and I'm the Principal Employment Lawyer of Advocation Professional Corporation. Our webinar this morning is Top 5 Employment Law Updates in 2016 and How They Impact You. And about Advocation, we are an employment law firm and we help employers and employees resolve their workplace and human resource issues so they can focus on work. Training Thursdays was created to give business owners, managers, human resources and professionals the information and strategies and tools they need to be able to proactively manage workplace resources. The webinars are typically held on the third Thursday of each month. However, we are holding this one on Tuesday. You might be able to tell by my voice that I am recovering from losing my voice, which I did last week. So I do appreciate your understanding and the fact that we've moved the dates. I will try to let you know ahead of time if the dates need to change, but rest assured we will always have a webinar once a month. Now, there's a new topic each month, and we have a great lineup for 2017. I look forward to having hosting you guys again and having great topics that will pertain to you and changing the webinar format a little bit so it's more engaging. So a little bit of housekeeping before we begin. As you know, we're using a Google Hangout platform, and as a result, there might be a delay between what you see on your screen and the audio. I apologize for this. We are going to be looking at transitioning to a new webinar platform in the new year, sometime in the second quarter of the new year. But until then, we're using this. So I do ask that if you're going through the webinar, not to pause and not to necessarily do anything that will cause you to interrupt the audio and visual. If there is a pause, there will be a delay, and although you'll be live, you won't be live at the same timing as us. So without further ado, what I'm going to do is get started. This topic is a sort of a roundup for the year and a way of sort of providing you with an overview from my perspective of some of the top developments in 2016. So what we're going to be looking at in the webinar today is we're going to look at Bill 132, which became law, which talks about workplace sexual harassment and harassment generally. A case that was a pretty huge case, Wilson versus Atomic Energy of Canada Limited. The third thing that I felt was a topic, top 2016, was overtime class action lawsuits. The fourth topic I chose was medical marijuana in the workplace. And the last topic was employee conduct outside of work, as that always rears its ugly head each year. So let's get started. So topic number 1, workplace sexual harassment legislation. The government has essentially boosted or built up its focus on sexual harassment. It comes on the heels of some of what we've seen with the Jian Ghomeshi case, but primarily because of lots of issues that were taking place on university campuses. So under the Occupational Health and Safety Act, the government has created more requirements on employers to be able to provide safe workplaces, specifically as it deals with harassment. So Bill 132 became law on September 8th, 2016. And then, as I mentioned, it amends the Occupational Health and Safety Act. And what it does is it places additional duties on employers with respect to the prevention of workplace harassment and workplace sexual harassment. Now, what are the changes? Well, for one, the definition of workplace harassment has changed. So it has a broader scope, and it does include sexual harassment. It requires an employer to develop and maintain a workplace anti-harassment program in consultation with the Joint Health and Safety Committee or health safety representative. Some organizations aren't large enough for Joint Health and Safety Committees, but there's still a requirement to have a workplace anti-harassment program. Employers are also required to establish complaint mechanisms for employees to report complaints or any incidents of workplace harassment. So this is, again, a positive obligation on the employer that didn't necessarily exist, or at least cleanly exist before. A new and big part of the legislation is it does require employers to have investigations when they deal with complaints of workplace harassment or sexual harassment. And so these are for any incidents and complaints. There must be a investigation. And if employer fails to have an investigation, the ministry can order an investigation, and they can pick any investigator, and that would be still at the employer's cost. So it's better to have an internal process for being able to investigate your own complaints. And also requires employers to, once they complete the investigation and they've made findings about whether or not the complaint has met out and what the penalties are going to be, it requires the employer to notify both the complainant and the respondent in writing of the results of the investigation and any corrective action that's being taken. Now, the ministry has helped employers by creating a code of practice with respect to these legislative changes, and those you can find, and they will create or provide you with some of the tools that you'll need to be able to ensure that you're compliant with this law. But here are what my best practices are for you to be able to make sure you're compliant. The first is that you're going to have to revise your harassment policy and program so that it complies with Bill 132. And what this means is that you're going to ensure that your harassment program, anti-harassment program, clearly has the proper definitions as required under Bill 132, that you have the complaint mechanism so employees know how they can lodge complaints and what's expected. You're going to also have to ensure that there is some kind of investigation team or investigator that you can appoint who's an impartial third party. Can be somebody in human resources, but again, you want somebody who is sort of an overseer of the organization. I don't recommend that it be a manager, and I don't recommend that it be any type of supervisory employee. You want somebody who knows how to do investigations properly. And you'll have to ensure that also there's expectations about what to expect once the investigation happens. I also say that's important that you not only create this policy and program, but that you make employees aware of it. So perhaps in your induction program that you are ensuring that people are made aware of the anti-harassment training protocol, but also that you'll want to make sure that existing employees on an ongoing basis know about it. And so that can be as simple as an email blast to employees that tells them about the program, gives them a link within your internal site, or attaches documents that explains how this program works, so you can show that you are compliant and that people know about it. There will be Bill 132 training that's being organized by me and another workplace investigator. So in the new year, I will be providing more details about that. So moving on, the second development for 2016 was the case that changed things for federally regulated employers, and that's Wilson versus Atomic Energy of Canada Limited. And basically, as we know, with employers, you can terminate an employee at any time for any reason on a without cause basis, provided that you provide the employee with adequate notice, either in accordance with the contract that you signed with the employee or in accordance with the common law. Now, that right was well understood, and employers were terminating employees, providing severance packages, and that there was no question about whether or not the employer was rightly or wrongly making any decisions about the termination. Then in July, the Supreme Court issued their decision in Wilson. And what it does is it's basically changed the rules for federally regulated employers. So now non-unionized federally regulated employees have job protections that are very similar to employees who are within unions. Now, just to give you a little bit background about the Wilson case, the employee, Wilson, he worked for Atomic Energy as administrator, and he was there for about 4.5 years. He was terminated on a without cause basis, and he was provided a generous severance package. But Wilson had a clean disciplinary record, and he didn't feel that there was any reason why he should lose his job. He was a good employee. He felt there was nothing wrong. He felt that it was because he had, blown the whistle or, kind of raised issues about procurement practices. And so he went to the Canada Labor Code and he filed an unjust dismissal complaint. And the unjust dismissal complaint allows the Canada Labor Code to make investigations into the workplace to understand why the employee was terminated, and if necessary, reinstate the employee. Now, the it was always understood that, if the employer was providing a severance package, no harm, no foul, there's no unjust dismissal. But with its decision, the Supreme Court effectively prohibited employers from just having random, or I would say non-business reasons termination. So if a federally regulated employer is now terminating an employee, they have to have either cause, meaning that the employee has done something wrong, kind of bona fide business reason for the termination. So if you're terminating some employees, you can't just randomly choose who you're terminating. You would have to have business reasons behind why you're terminating or choosing to terminate a particular employer or group of employees. So that would have to be reduction of the position. It would have to be, because of, changing business needs. And remember that if you're reducing the position, then you can't turn around and hire for it, because it would be an unjust dismissal, and the employee that was terminated would be entitled to reinstatement. So it's a pretty big case for federally regulated employers, because they're now far more restricted in what they can and can't do with respects to employee terminations. So what are the best practices? Well, for most people on this call, and for most of people in Ontario, they're not going to be, subject to Canada Labour Code provisions. We fall under the Employment Standards Act. The federally regulated employers are few and far between. However, if you are a federally regulated employer, you have to make sure that you have objective, business-based criteria for any terminations that you're going to be doing on employees. And you want to make sure that those are well documented. And I also say that's important to centralize your decision-making. So it's not necessarily a manager who's doing the termination, who might be doing it out of emotion, but that it's done either with human resources or in consult with other managers. So you know that whomever you're reducing from your workplace is, a bona fide workplace reduction, and it limits the chance that if the person goes to the Canada Labour Code and protests the fact that they were terminated and brings forward an unjust termination complaint, that they will not be successful, and that you're not necessarily going to have to reinstate this employee back in your workplace. I would say that there's also lessons for Ontario regulated employees as well, because although we're not subject to these laws, I would say that case law generally tends to favor employees who are terminated. So a lot of the best practices in making sure that you have good documented reasons for the termination, also centralizing that decision making and ensuring that you're managing the terminations in a proper way will go far in ensuring that you can limit your legal liability. All right, so the third issue for 2016, overtime class actions. And overtime class actions, I only thought of this topic because it's one that never really seems to go away. So in November, Good Life Fitness was faced with a class action lawsuit, or at least a class action lawsuit was commenced for $60 million related to unpaid wages. And that was like overtime and some other work that employees were doing but weren't being compensated for. And this isn't the first time we've heard about class action lawsuits. In July of this year, BMO Nesbitt Burns settled an overtime class action lawsuit for $12.5 million. And in May, an Ontario judge approved a $20.6 million settlement in the case of Scotiabank for their overtime lawsuit. And CIBC also has an overtime class action lawsuit. I'm not exactly sure where that is at the moment, but the numbers are very large. And although with most employers who are on this call, there's not a chance that you'll have a large class action that's going to be in the millions of dollars like these employers, there's still a very, very good chance that you might have overtime issues across your organization. And so it's always very important to make sure that you're doing what you need to do to ensure you're not going to expose yourself to that particular liability. Remember that under the Employment Standards Act, employees are entitled to overtime for work that is in excess of 44 hours a week. And overtime pay is time and a half of the employee's regular rate. Now, part of the reason why we're seeing overtime lawsuits that sort of are coming in is that employees have 2 years from the time that they are not paid to bring forward an overtime lawsuit. So if there are employees in your workplace who have not been provided with overtime pay, they have 2 years from today, so that would be since 2014, for which to bring a lawsuit forward, and that can be quite significant. So what can you do as an employer to minimize your chances of having any type of overtime claim that would go across your workplace? First, you should complete a classification audit of all of the roles within your organization. The new year's starting, it's a perfect time to go through, look at the job descriptions, figure out if these people, the people who are doing the work or the actual role is overtime exempt, meaning that it's not entitled to overtime, or whether or not the legislation, the Employment Standards Act, requires that you pay overtime to these employees for work over 44 hours. Also make sure that you have a very clear overtime policy so employees aren't working more than they're allotted for up to 44 hours per week. If an employee is working more than 44 hours a week, you want to know, you want to make sure that you're managing it, you want to make sure that you've approved that work for them and that you're paying overtime and that you're clearly documenting it. I would also say that in your contracts of employment, you'll want to make sure that you're saying that whatever wages employees are earning, especially if they're salaried employees, that the salary is for work up to 44 hours a week. So you are able to include any hours over 40 hours a week, because if you lend your employees to believe that the salary is based on 40 hours a week only, then if they're working up to 44 hours a week, even though they might not be entitled to time and a half, they might be entitled to additional compensation for those additional 4 hours a week that they might be working. So you want to make sure that you're mitigating against those particular issues. Again, classification audit of all of the roles within your organization to determine which roles under legislation are overtime exempt, ensuring that you have an overtime program so employees can't work more overtime without express approval from a manager, and ensuring that employees are paid for work in excess of the 44 hours a week. Now moving along, another tricky issue that's raising its head is medical marijuana in the workplace. Right now, 75,000 Canadians are authorized to use medical marijuana. So they have a certificate that allows them to use marijuana for medical purposes. Health Canada expects that this number is going to increase to 450,000 people by 2024. So we're looking at close to 500,000 people who are going to be using marijuana to be able to manage their medical issues. Now in Canada, possession of medical marijuana is controlled under the Access to Cannabis for Medical Purposes regulations, and that recently came into effect in August of 2016. And the regulations allow individuals with certain illnesses to use marijuana to relieve their symptoms, and also remember that marijuana is still an illegal drug. So it's legal only for these people who have a certificate that allows them to use it for to treat these medical symptoms. Now, the flip side of the coin, that although marijuana is illegal now, in the spring of 2017, the federal government is expected to introduce legislation that's going to legalize marijuana. So marijuana use within the workplace is going to be probably not within the workplaces and people actually smoking within the workplace, but use by people, your employees within the workplace, is going to increase. Or it might have already, increased without you knowing. So you want to make sure that you are finding ways to manage any issues. Now, the biggest issue with marijuana is that the impairment from the use of the drug can be problematic in safety sensitive situations, because the impairment based on the drug might not allow somebody to function fully in their particular work. And now there were two cases this year that kind of looked at marijuana, two cases that I, so wanted to highlight that looked at the use of medical marijuana. The first one was in New Brunswick. It was an employee who was terminated from employment because she was found to have marijuana on her possession. And it was obviously seen as an illegal drug, and the fact that she had a legal drug and she brought it into the workplace, the employer felt was grounds for termination. This employee was a unionized employee, and that's what you tend to find with a lot of these cases, because they haven't made their way up through the court system, but within the arbitration and tribunals, they have with unionized employees. And this particular employee the termination was upheld because she didn't have the necessary authorization to carry marijuana, and because it was a legal drug, she had brought illegal drugs to the workplace. It was a policy that they could not have illegal drugs within the workplace, and so her termination was upheld. The second case was a bit more interesting and sort of touches on the human rights issues that I think are going to come into play with medical marijuana in the workplace. So in this particular case, the griever was, again, a unionized employee, was prescribed medical marijuana to relieve anxiety and chronic pain. He got the job. He passed the pre-employment drug and alcohol test because he abstained from taking marijuana for a 2-week period before he had to take this test. But he resumed his consumption of marijuana after the test was administered. During his pre-employment orientation as well, he read and signed a health and safety handbook from the employer, which required employees to report use of any medication which could impair their ability to work. He also completed and signed a medical questionnaire, but he deliberately left blank information about any medications he was taking and whether or not they had any side effects. Now, after commencing employment, he started taking marijuana almost on a daily basis, and he would keep it sort of on his person. And one time, someone smelled marijuana on him, as you probably would, because marijuana has a very strong smell, and he was terminated for cause. And of course, the employee alleged that, under the human rights, the employer has a duty to accommodate him, and that his medical use of marijuana should be accommodated. Now, the arbitrator in the case felt that yes, it's true. The employee does have a right to use medications to treat a medical condition, and the employer does have a duty to accommodate. But in this situation, the employer was very clear about requiring employees to report any medication that might impair their ability to work safely. And also, prior to the employment relationship starting, the employee also had to disclose any impairment and failed to do so. So the arbitrator in this particular case felt that the employer's policy satisfied the 3-part test that was established by the Supreme Court of Canada, that the use of marijuana in the workplace created health risk or safety risk, I should say, not health risk, and that the employer's denial of the use of this, allowing this employee to use marijuana was, although a violation of the Human Rights Code, still a bona fide job requirement. So how can you take this case and its findings and apply it within your workplace? Well, first of all, there are probably employees within your workplace who are using marijuana either illegally or for prescription purposes. And I think for those particular employees, you want to make sure that you have a very clear policy on reporting anything, especially medications, that might impair their ability to do the work safely. So address your people who are taking prescription marijuana the same way you would do with any other prescription medication that might cause somebody to not be able to do their job properly. Remember, as an employer, you are entitled to inquire, and employees have a duty to report any impairment that might result from prescription medication, which would impact the safe functioning of them being able to do their job. And again, this reporting has to be established through your workplace policy. So if you don't already have a workplace policy that deals with prescription medication and medical marijuana, definitely work over the holidays to draft one and bring it forward in the new year. Now, if you're going to deny an employee's use of medical marijuana, you'll want to make sure that you're meeting the 3-part test that the Supreme Court has brought forward. So for the test, you want to make sure that your policy is adopted because it's rationally connected to the job function being performed. If the person is working as a teller at a bank, there's less safety sensitive issues there. So you wouldn't necessarily have to prohibit the use of medical marijuana because it's not necessarily going to harm the job function. However, for somebody who's working with machinery or driving or in in a way that could harm themselves or somebody else, either a client or another coworker, then the policy makes sense as it relates to the particular position. The second is that you're adopting it in good faith, meaning that you're not targeting anybody, you're not doing it to necessarily limit any employees, you're doing it because you're looking at the safe functioning of your workplace, the safety of the employee who might be using the marijuana, as well as other employees and your clients. And the third is that the policy has to be reasonably necessary to accomplish the purpose or goal. So is there something else that you can do? Is it possible that the person can still use the marijuana but work in a, in a more modified way? Or is there a way that you can still allow medical marijuana within the workplace and find other ways to be able to reduce the risks? If you can, then you might not meet the test. But if basically the person is a driver, it's hard to think of any way that you can make driving less safe if somebody is using a drug that's going to impair them. So in that particular situation, you would be able to get away with not necessarily allowing the person to use medical marijuana. But again, treat medical marijuana like any other prescription medication, but ensure that you do have a policy that clearly addresses and lets employees know that they have to disclose not necessarily the use of medical marijuana, but the use of any drugs that might impair them, and that you're doing it for any type of safety sensitive positions, because you might create greater liabilities if that person goes on to hurt themselves or somebody else. Now, the last of the 2016 issues that I wanted to bring up was employee conduct outside of the workplace. And again, like overtime, this is one that continues to rear its ugly head. A few years ago, 3 Toronto firefighters were fired after inappropriate tweets. They had sexist lines from some TV shows that they were watching, but of course these were public. They were firefighters. They were terminated because they didn't necessarily represent the brand, or the fact that people would feel safe knowing that some sexist firefighters are there to actually save or help you. We all heard about the Hydro One employee who was fired after heckling a city TV news reporter at a Toronto football club game. Everybody's heard about the Giangameshi case. And most recently this year, there was a guy at a Blue Jays game who tossed his beer can on the field. He was later on fired from the media company for which he works. So with social media, there's a lot more ability to capture your employees doing some repugnant things outside of the workplace. And employers are taking a harder stance and cracking down. There was a case that took place this year, Syndicate de Travail, a French case, where 2 employees were involved in a violent altercation outside of work. And the complainant, again, these are unionized employees, was angry over a colleague for some kind of unpaid debt. The employee had loaned the colleague money. The colleague hadn't paid him back. So he decided to take action by taking a crowbar and basically damaging the guy's car, blocking him on the street as he's driving, and then damaging his car. Escalated into a very physical issue. Employee terminations were meted out, and the argument from the employees were like, well, this had nothing to do with work, so why are we losing our job for something that has absolutely nothing to do with work? The trader in that position basically felt that it was sufficiently related to work because, one, these employees are going to have to continue to work with themselves, work with each other in the workplace. And if there was any kind of violence, it could carry over and spill into the workplace. And as we've seen from other examples with the Toronto firefighters, even with the Hydro One employee, what the courts and what any arbitrator is going to look at is to see whether or not the conduct the person is engaging in is connected at all to the workplace. So, for example, with the firefighters, because they are charged with helping people and they have to be seen as credible people to assist in emergency situations, it's a high level of trust. To know that your firefighter was making sexist, very gross comments, and they had to rescue you, that might not necessarily make you feel confident. Same with the Giangameshi case. He is somebody who was the face of CBC for their programming, and when he was doing something repugnant outside of work, well, basically it brought to bear negatively on CBC's brand. So if you are looking to discipline your employees for conduct outside of work, I say one, use your powers to be able to do this, which you're allowed as an employer, but use your powers to do this very carefully. It's not something that you want to just do willy-nilly. The big brother thing is becoming a problem within the workplace as well too. So employers who overstep their boundaries and are too involved in employees' personal lives could also backfire. But if you're going to exercise disciplinary power and in termination specifically, make sure that the person, the repugnant conduct outside of work is related to their job. Again, if you're looking at an employee who was caught driving under the influence and, you know, didn't pass a sobriety test or did something wrong outside of work, your ability to sort of come down hard on that employee would be different if they're working as a teller versus if they're working as a delivery driver. As a delivery driver, it's far more connected. Somebody who's making sexist tweets on social media or repugnant statements about women or groups under social media, very different if they are, you know, somebody who's a file clerk who doesn't really work with a lot of people, or versus somebody who might be a manager who has to manage a team of people, or somebody who has to deal with clients in a way that requires compassion. So let's say they're a personal support worker or something like that. So make sure that whatever conduct that you're looking to discipline or even fire for, it is somehow related to the conduct within your workplace. And with that, I will take any questions. I should have told you to type your questions in at the very beginning of the webinar, simply because of the delay, but hopefully there will be some questions. If not, again, we will be having our regularly scheduled webinars on the third Thursday of January, which is January 19th at 9 o'clock until 9:30. This one will be on the top 5 common employment contract errors. I see this all the time, both from my employer clients when we're looking at changing their contracts when they first come to me, and also when employees have lost their job and we're trying to see if we can get a better severance package. They show their contract, and the contract was obviously there to protect the employer, but fails to do so and has created a number of liabilities. So I want to go through the top 5 ones that I see that are problematic for employers, so you can be able to make sure that your contracts are up to speed. Doesn't look as if we have any questions. So what I'm going to do is thank you very much for your time and attention this morning. As I say, time is the most precious resource, and the fact that you're spending it with me this morning is greatly appreciated. With respects to the webinar replay, it will be available. Apologies for the other replays. I will be sending an email that has all of the replays and access to the replays, so you can listen to any that you missed this year. And I finally want to wish you fantastic holidays. Hope they're safe. I hope that they're restful and enjoyable with your loved ones. And I thank you again very much for your support of Training Thursdays this year. And I look forward to continuing to provide you with great content and useful information in 2017. Thank you very much.